All right. Good morning, everyone. Good morning. Welcome back. I'm Josh Blackman. I'll be your property professor. Very happy with all of you. So a good thing for you first, my first day teaching was my birthday. And I don't need a... So just look on the table, thanks. So my first day teaching was my birthday some years ago. And as a tradition, I brought in cookies for the students. And then one year, I forgot to bring in cookies. And one of my students watched the old video, and she's like, where are our cookies? So I do not disappoint. So these are for everyone. Just take one, pass it around. I have more than enough for everyone. Costco, they're very good cookies. So the second thing I will pass around is the seating chart. Please write your name facing up, so when I read it, I don't have to do this. I appreciate that. Also, I am passing around these name tent cards. This will help me learn your name much quicker. Put this in front of you. You can fold it up right in front of your seat, and that way I'll learn your names much quicker. If, for whatever reason, your name is not in here, I have a few blank ones. Just write your name in big letters. If you have a nickname that you prefer, cross this out and write your nickname. I don't care what to call you, just I want to call you something you'll answer to. So find your name in the stack, eat the cookies, find your name, and now we can get started. So was everyone able to get the textbook? Yes? Good. Everyone able to get the first assignment?
Yes.
Very good. Okay, I'm glad to hear. Just so you know, that thing there is a camera. All the lectures are recorded. They're on YouTube. You can watch them. I strongly encourage you to watch the videos from the last time I taught this class. It will make your life a lot easier. If you ever find yourself unable to know what the answers to questions are, odds are I asked it last year, so just watch the old videos. Also, to the extent that you're all taking notes, try not to type verbatim everything I say. It's not a good use of your time. If you miss anything, you can watch the video on YouTube after class and fill in any gaps in your notes. This is how you do well in the class. It's not a secret. So I want to start off walking you through the syllabus, however briefly, to give you a sense of what to expect this semester. The textbook you'll have, the exams at the end of the semester. It's going to be open book. Whatever you want, doesn't matter, won't help you. There will be a midterm. I grade the midterm, but it won't count towards your final grade. Unless you fail it, in which case I haven't done that in a while. It may hurt your final grade, but generally this is your wake-up call. With respect to the midterm, I want to see every one of you. And in a couple weeks, I will send around a link that you can schedule a meeting with me for 30 minutes, one-on-one, to go over your midterm. I realize you haven't even started the class yet, but this makes sure I get to know all of you, because in a big first year or second year class, you often don't even speak to your professor the entire semester. For your benefit, I've posted every exam and midterm ever given with the A+ answer. You should take your time to go through that and look at them at some point. This will help you prepare. For class participation and attendance, I'm trying something new this semester. If it works, I'll stick with it. If it doesn't, I will drop it. How many of you have used a clicker before? In college, have you used it in South Texas?
Yeah.
Did you use the iReef, iClicker?
Yes.
Yeah.
Professor Field?
Yes.
Oh, beautiful. So you guys know the drill, right? So do you all have the app already installed on your computer, your phones?
Yes.
Okay, good. I don't have anything for today because I wasn't sure if you had it yet. But on Thursday and every other class, what I'll do is when you walk into the room, there'll be a question on the board, multiple choice. I want you to answer that question. I'm not grading it. That is for you to see, did you understand the reading from last night? And that will also be your attendance. So I don't want to pass around a roll sheet. By doing that thing on your phone, it will mark that you're attended. I have your number. We'll keep it cool. If you don't have a laptop or a smartphone, write your answer on an index card. Low tech, right? And just bring the index card up to me at the start of the class, and I will know you're there. The plus side, though, of this form of grading is after I close the polling, you are marked absent. So make sure you're here at 10:40 to put your answer in, and that way we all have a good attendance record for the course. Okay? My office hours are basically right after this class, starting at, I guess we finished at 10 after. So if you have any questions, just follow me upstairs and I will answer any of your questions. You can also email me. I put all the links to my past lectures. I encourage you to watch these. These are for your absolute benefit. You've noticed that I put a very detailed schedule up for the semester. I will stick to it. I have never once fallen behind in all my years here. So whatever pages I say we'll cover this. It's not read 20 pages ahead, it's read those pages. And I work to make sure that all the readings are of a manageable length. 20, 25 pages, sometimes 30, maybe 35 once or twice, but it's usually going to be under 30 pages. That means you have to read. The reason why I encourage you to read is the way that I do recitation. It's different than how other classes do it. I don't have people raise their hands. There's no on-call roster. What I do is I start at one end of the room and I go up and down the rows. Everyone gets one question, maybe two questions, maybe three. And your question is going to be a follow-up on what the person to your other side was asked. So you have to follow along. My sincere goal is to make this entire class into a discussion group. Now you're a small section, what, about 50 odd people? This is pretty small, you should have 90. So I can probably call just about everyone in one class. Maybe 40, maybe 35, but if I'm on a good roll, I can probably do just about everyone. And you don't know where I'm going to start or finish, so everyone's on call every day. This might sound scary, but it's for your benefit. You want to be paying attention and ready to roll throughout the entire semester. So the syllabus is here, all the dates are here, all the readings are here, everything you need to know. Again, this schedule will not deviate, so you know from now till December what's expected of you. The midterm is on the 3rd of October, so it's roughly the halfway mark of the semester. The final exam is on the December the 7th. Okay? Any questions about the syllabus? Any questions about the framework of the class? Did anyone not get any cookies? I see this box here and it shouldn't be here. Does anyone lack in cookies? No? All right, I'm going to leave these here and take them on the way out, okay? Oh, this is not right. I don't know what's going on there. Something's not right there. So I apologize that that screen is not working right. Okay. Hi, welcome. Okay. All right, so any questions before we get started?
I have a quick question.
Yes.
Have you set up the property class on Reef yet?
Yeah. Oh, I set up common law. I'm sorry. I'll set it up after this class.
Okay.
I'm sorry. You're exactly right. I set my other class. I didn't set this one yet. But I'll do that after class today. And but you guys use it. You know how to use the software. I don't have to demonstrate it again. Perfect. I'm so glad to hear it. Professor Field actually did a workshop for the faculty to explain how to use it. And he's like, "This is great." So I'm copycatting. Okay. So let's start our class today. Property 2 is different than property 1. In property 1, whether you thought about it or not, the only way that property changed hands was when someone died, right? Or someone got sick, or someone had the birth of a child, right? All of the sorts of property transactions you had last semester were in a very arcane, old-fashioned sense. Property 2 is what you all probably thought property was about. This is a far more modern class, a far more practical class, which involves real estate transactions that actually occur outside the confines of law school. So it's a very, very different class. We'll cover topics starting with adverse possession, but then we'll go on to topics like land use and zoning and mortgages and contracts of sale and real estate transactions and a lot of other aspects that you may be much more familiar with. You're going to learn a lot in this class, and I want to encourage you to simply not just memorize rules blindly. Theories often get a bad rap in law school. Students don't like them, but these are mere tools you can use to understand and apply these various doctrines. Okay? Again, one note on the video, I make this point very clear. That's not a substitute for coming to class. I will be taking attendance using the little clickers, and if you're not there when the quiz is given, you're absent. So be sure you're punctual. This is a 10:40 class, so you don't have rush hour as an excuse as you would at 9 o'clock. Any other questions before we get started? No? Okay. So you will recall at the very beginning of Property 1, at least I think you would have covered, is how to acquire stuff, right? Flashback all the way to last semester. You'll remember you studied how to hunt foxes, right? Remember this? How to hunt whales. Yeah, now it's coming back, right? How to acquire oil and gas from the ground. If you steal stuff, and if you find stuff. Do you remember the classes on finders keepers? Right? Remember this? This was what we all know when you're a kid. If you find something in the ground, you find a toy, and someone says, "That's mine." You go, "No. Finders keepers." You all know this, right? The very first topic we're covering today, adverse possession, is the ultimate game of finders keepers. Because it's not enough for you to find it. You have to keep it. And you have to keep it for a period of time long enough that the courts decide, okay, you are now the owner of this property. And I want to start this class by playing a video. This video is now a couple years old, but it's from Flower Mound, Texas, outside of Dallas. And it involves a person who paid attention in class, perhaps, and learned about adverse possession. So I'm going to play this video, and it's about 3 minutes long.
What if you could live in a new home without a mortgage? A man at Flower Mound has done it, moved into a $300,000 house, and he only paid $16 to do it. It's a little-known Texas law, and the foreclosure mess could have him living on Easy Street, but his neighbors, well, they're less than thrilled. Channel 6 Casey Norton has this exclusive from Flower Mound. Flower Mound's Waterford Drive is lined with well-manicured $300,000 homes. So when a new neighbor moved in without the usual sale, mortgage-paying homeowners had a few questions.
What paperwork is this, and how is it legally binding if he doesn't legally own the house? He just squats there.
Lee Lowry and her husband told me the house down the street was in foreclosure for more than a year. The owner walked away, then the mortgage company went out of business. Apparently, that opened the door for someone to take advantage of the situation. Kenneth Robinson told us he's no squatter. He says he moved in on June 17th after months of research about a Texas law called adverse possession.
This is not a normal process, but it's not a process that's not known. It's just not known to everybody.
Robinson says this piece of paper gives him rights to the house. It's an online form he printed out and filed at the Denton County Courthouse for $16. Says the house was abandoned and he's claiming ownership.
I went through, looked at it, and added some things here, you know what I mean, for my own protection.
The house is virtually empty, just a few pieces of furniture, no running water or electricity. But Robinson says just by setting up camp in the living room, Texas law gives him exclusive negotiating rights with the original owner. If the owner wants him out, he would have to pay off his massive mortgage debt, and the bank would have to file a complicated lawsuit. Robinson believes neither is likely, so if he stays in the house, after 3 years, he can ask the court for the title. That's your goal eventually, is to have title of this home, to be the owner of this house.
Absolutely.
And
I'm on record, you know, at this point, you know, since I possess it, I am the owner now.
Robinson posted no trespassing signs after neighbors asked police to arrest him for breaking in. But Flower Mound officers say they can't remove him from the property because home ownership is a civil matter, not criminal. Lowry and her neighbors continue to look for legal ways to get him out.
Or if he wants the house, buy the house like everyone else had to. Get the money and buy the house.
Robinson says he's not buying anything. As far as he's concerned, the $330,000 home is already his, and he has the paperwork to prove it. Casey Norton, Channel 8 News.
Now, foreclosures are down for the 6th month in a row in North Texas. August filings fell 14% compared to last year. However, something to keep in perspective. Foreclosures are still 313% higher than in August of 2000.
All right. Had anyone heard of that story before or seen on the news?
Yeah.
Okay, so you remember this story, okay. I'm going to just start here. Robert, what do you think?
About this story?
Yeah. Video, what do you think?
Adverse possession in general?
Yeah, what do you think?
I think it's trying to put land to its best use.
Ah.
That's the idea behind it.
So Mr. Robinson there, right? Is he putting the land to its best use?
If nobody's in there and it's just sitting empty, someone should be using it.
So what is he doing to improve the usage of the land? Mr. Robinson right there.
By being in it and possessing it.
Okay. Actually, what do you think about this situation with Mr. Robinson in the house?
I think that the theory of adverse possession is useful and relevant, especially in this situation, because it's actually being put in use. The mortgage company is non-existent. The owner, original owner, is absent. So if no one's using the home, then he can use the home. And then at that point, he can mix it with his labor or do whatever else.
Labor. Someone paid attention last semester. Very good. Virginia, what do you think? What do you think?
I think it's smart. I mean, they're right. He's actually using the house. Yeah, he doesn't have electricity or running water, but he's still living there. It's not just empty and sitting there.
Ah. Okay. So now the next question I'm going to ask is one I'll ask throughout the entire semester. Jonathan? Yes. Jonathan, I love these name tags. I may have to get them a little bit bigger because these fonts are hard to read. Can anyone actually read this from the back row? It's tough. My eyes are getting worse. You can measure my aging. So when I started teaching, I didn't have glasses, and now I do. Jonathan, let me ask you this question. Is this fair that Mr. Robinson can go to the courthouse, pay $15, whatever it is, get some paperwork filled out, signed, go into a $300,000 house, says, it's mine? Is this fair? Why not?
I wouldn't say it's fair. I mean, because like the neighbor, or I guess for the adverse possession, where it's kind of, they're using the property, and it's kind of, but at the same token, I mean, what if the foreclose on it? I mean, that could be revenue another way.
Ah, revenue another way. Or is that, who's that, John Paul?
Yes.
Yeah, what do you think, John Paul?
Whether it's fair?
Yes, it's fair.
Fair to whom?
Oh, what are the sides? You give me that. What are the different sides of this question?
Is this fair to the true title owner? No.
Who's the true title owner then?
I mean,
understanding, the way I understood it, it said that the true title owner was aware of his...
The bank. They knew he was there.
The bank knew, but the true owner.
Well, the true owner's gone. They had a mortgage and they didn't pay their bill and they absconded it.
Sure. Probably to the bank and other homeowner.
Now, one time, please. The only rule I have in this class is one person speaks at a time. That's the only rule I have. Nothing else. Everything I want, you can raise your hand and say, but one at a time. Jared, is this unfair to the bank that he's sitting there squatting?
I mean, they know his presence is there, and there's really pretty much done about it.
Now, this was an early news report, as you can probably guess. Does anyone know what happened to Mr. Robinson after this report aired on the news?
People broke out the windows.
I'm sorry?
People broke out the windows, beat up the house.
And eventually what happened to Mr. Robinson?
He left.
Yeah, they threw him out. So the way yeah, that's right. It was a messy situation. Basically, the bank moved what's called an action in ejection or an action in eviction, as you probably know it, and they have him thrown out of the house. Right? That probably wasn't surprising, right? But let's say, right, that Mr. Robinson wasn't so open about it, right? He didn't go on the evening news, right? I can't see your name tag.
There is no.
Oh, you've got it. Okay, sir. What's your name?
Tommy.
Tommy. What would have happened if Mr. Robinson played it cool and like he didn't go on the news and he just sat there quietly? He followed his paperwork in the court, but he didn't This guy actually went to SMU Law School and gave a class on adverse possession. Like he actually took this really seriously, right? But let's say Tommy, this guy, he played it cool, low key, didn't call anyone up, and he actually made it 5 years.
It would have been his.
Yeah. And then would that have been fair?
Yes, I think it's completely fair.
So why is that there 5 years on?
Well, I think it's just fair in general because everybody else had the exact same opportunity to do it, and he's just the one who took advantage of it.
Ah, okay. All right, person about to get the paper. What's your name, sir? Yusuf. Okay. So when you watch that video, there was one point that I thought was important. He said he went down to the courthouse and he filed some papers, right? And then he said, "I'm not the owner. I'm the record owner." You remember what he said that a minute ago? What's he talking about? What was he getting at with this paperwork and this record owner?
Maybe that he's not the true owner until those 3 years pass.
So wait a minute. Are you telling me that property can have multiple owners at once?
Yeah.
What do we call that? What's that metaphor, that image we use to describe what you just described? Oh. Ah! Give him an extra cookie, yeah. The bundle of sticks, right? This is this theory which was drilled into your head in Property 1, that property is not like a single stick, it's a bundle of them. And different people can have different claims to a given piece of property at different points in time. So you have this house, right? It's a piece of real property, there's a house on it. The bank has one claim to it. And then Mr. Robinson over here, with his paperwork, has a different claim to the property. Right? And so what's your name?
Walker.
Walker. How are courts to adjudicate whose stick is better? Like who, which stick in that bundle prevails? Right. I mean, that's your question in property, right? I can give you your final exam question will be that, right? Who has the stronger claim to a piece of property? I'm giving you the question. I don't know what the facts are, but that's going to be the question, right? Who has a stronger claim to a piece of property with two plaintiffs defendants? So Walker, how do courts adjudicate in general who has a stronger claim to property?
Whoever has the title.
Well, no, they both have title here, right? The bank has one title, and then Mr. Robinson has his paperwork, different title. What do we do?
I mean, I guess they would determine whoever has the stronger claim based on a number of.
Well, okay, so this is a Texas case, right? So in Texas, what would a court look to decide how to adjudicate this claim? It's not an abstract question, it's the basis of our reading today.
Whoever was using the land to its best use.
Okay, well.
More productive with the land.
Okay, that's a good theoretical question. What's your name, sir?
Chester.
Chester, okay. In general, courts in Texas or elsewhere, how are they supposed to adjudicate a dispute like this, right? Mr. Robinson moves in, the banks have done enough hours, they both have these pieces of paper. How is a court in Texas or anywhere else supposed to resolve this dispute? What do they have to look at?
So we would have to break down adverse possession. Opening notorious hostage.
Yes, exactly right. You often think of the 4 elements of adverse possession if you're memorizing. No. You have a court. Mr. Robinson goes to court, the bank goes to court. They have to decide who has a stronger claim to adverse possession. And before we drill down to those 4 elements, and Chester, you're exactly right in listing them, we'll get there in a couple minutes. Before we go down to those 4 elements, let's think for a moment. And by the way, if you write your name by hand, make like a mark or something, because I can't see the little skinny pen marks. So yeah, just make it nice and thick so I can read it. But before we get to the 4 elements of adverse possession, we have to ask ourselves, how long has the person been in there? Right? At bottom, adverse possession is a statute of limitations. Right? Ma'am, what's your name? Simone. What's a statute of limitations in general?
Usually it's like a limitation of years where somebody can either bring a case for something in any type of law.
Good. Why do we have statutes of limitations, Simone, in general?
I think as a policy reason we have it because something that happened in 2017, something that I did, I shouldn't be able to be sued for that in 2048.
Why not?
Just because that's a waste of time. If you really wanted to bring the suit against me, you should have did it when you had the time.
Okay, good. Ma'am, what's your name?
Kayla.
Kayla, what's another reason why we have a statute of limitations?
I mean,
Oh, evidence. So you're taking evidence this term, this semester? Why do you think, I mean, I'll use Simone's example. She said you committed tort in 2017 and then someone brings a lawsuit in 2040, right? What are some of the evidentiary issues that may exist if you bring a claim like, 30 years later?
I mean, might not be able to find the witnesses
Yeah.
around or...
People forget, right? Memories fade. Evidence vanishes. Today we have, computer electronic records, so things are a little bit more stable, but imagine back here in jolly old England where property one took place. You have some old piece of parchment that records some transaction for land, right? That parchment may disappear after 30 years. So the idea of a statute of limitation in general is to ensure, primarily, that you have good evidence. It's true, Simone's right. You don't want people to be sitting on their claims for decades. It creates uncertainty in the law. Let's get things settled. But statute of limitation with adverse possession is primarily about getting someone to bring their claims at the right time. So, Philip, let me give you an example, right? Let's say that Texas, this is not true, but let's say that Texas makes the statute of limitation period 30 years. I'm making it up, right? What does that mean for persons with adverse possession if the statute was 30 years? What would that actually mean in practice?
That someone who is bringing a claim against the adverse possessor would have 30 years to bring a claim?
Right, and what's the cost of having a 3-decade limit on adverse possession?
The cost?
Yeah, what's like the cost of that, of such a long statute?
Well, it makes it so that the person could be, they could set up the guy in the video, he could be in that house for 28 years, be set up, be building his life there, and all of a sudden...
On year 29, right, they knock him out. Yeah. But the flip side is, what happens, Valerie? Yes. Valerie, what happens if they made the statute 6 months? Do you think Mr. Opton could have snuck by maybe 6 months to be laid low?
Yes.
Yeah, what would have happened if they made it 6 months?
Well, it wouldn't have been fair for the other people to notice him there.
Yeah. So perhaps there would not have been enough time for the bank to even become aware the guy was squatting in the house. So the decision of how long is appropriate was long ago set at common law, right? By that I mean courts made it up. They said, well, if there's been any adverse possession for 20 years, 30 years, since the king was, crowned, right? Coronation. We have it a little bit easier. In every state in the union, the legislatures have fixed by statute the appropriate time frames for statutes of limitations for adverse possession. And I have up here the Texas ones. We don't do a lot of Texas law, but when we do have an overlap, I always like to bring it in for you. You'll need to know in a couple of years anyway. Texas has 3 different periods for adverse possessions depending on the circumstances. Okay? The first one is what's called color of title. We'll get there later in the class today, but if you have some sort of color of title or some sort of deed, some sort of paperwork that might not be valid, your limit is 3 years. So if you have color of title, this is section 16.024, not that you'll need to know it, but it's there. It's a 3-year limit. So you have to have some sort of paperwork to show you have a claim to the land. The next limit is 5 years. If you have some sort of deed, maybe the deed's valid, maybe it's not, 5 years for having some sort of deed. Okay? But what about if you have nothing? You have no paperwork and you sit there and you go squat. The limit's 10 years. So you have to sit there for an entire decade under Texas law before you can bring such a claim. Okay, everyone get that? So one second. So the legislature sets by statute the appropriate limit. Now, I'll get you. I still can't read. What does that say?
Jesse, I have a...
Yeah, no, just make it later. Just get like a Sharpie so I can see it nice, big and bright. Yeah, Jesse.
Yeah.
Oh, or it might be there.
I didn't see it, but.
Cool. Jesse, what's your question?
I was confused. It said 3 years for color of the title, 5 years for a deed. Is that deed have a defect in it? I don't understand.
It might be some sort of defective deed, yeah.
What's the difference between color of title?
Mr. Robinson, no, he said 3 years. We were listening in his video, he said 3 years. Yeah. He went and he registered his paperwork with the court. And I think in his mind, he had a color of title. The difference between color of title and a deed is actually fairly iffy. But in this case with Robinson, I think it's a safer bet for the 3 years because he actually brought it to the courthouse, so that there's some public record, right? Whereas a deed, if you have it in a box in your basement, no one knows about it. The reason why you have these different limitation periods, Jesse will ask you, why do you think it gives 3 years if you have some sort of color of title at the records office, 5 years if you have a deed sitting in your basement somewhere, and a decade if you have no paperwork, right? Why do you think they put different timelines?
There's open and notorious requirement that the person would know somehow.
That's exactly right. The more public you are about it, the more open you are about it, the time frame shrinks. Because the other person is more likely to find out about it. But if you have no paperwork, nothing, you have a decade. And then maybe over that decade, the other person will find out about it. Is that Tommy?
Yes. During the time he was in the house, if he kept going, would he have to pay taxes?
Oh, what a good question, right? So in some jurisdictions, I don't think Texas has this, but in some jurisdictions, to claim adverse possession, you have to pay property taxes. Why do you think that's a good rule?
Because it keeps people, for instance, if there was a $50 million mansion, the property taxes on that would be substantial per year.
But what's the consequence of paying property taxes? What does that signal?
It's that you own it.
And it signals to who that you own it?
True. Everybody.
Yeah, one at a time, but you're right. The true owner. Exactly. The act of paying property taxes means you own it, and you're making a public record that you own it, and that the true owner can come back and find out. So some places actually require property taxes to acquire through adverse possession. That make sense? So the book gives you a fairly lengthy discourse on the history of adverse possession, but I think it can be summarized in 4 words. You snooze, you lose. If you sit on your rights for too long and you don't enforce them, and you know that someone is on your land and you don't take any steps to eject them, whether in 3 years, or 5 years, or 10 years, or whatever the limitation happens to be, sucks for you, right? You should have brought your claim earlier. You didn't. And your failure to do so means that your claim is no longer going to prevail. There's also the fact, someone mentioned this earlier, the law likes putting property to its higher purpose, to its higher use. Having an empty house sitting there for 3 or 5 or 10 years is not very good. You can have people breaking in, someone broke in already, people making a mess, right? Letting the garden go big, maybe he'll mow the lawn, I don't know. But you can make the land better. A better example is if there's farmland. Imagine that someone's squatting on a farm and they actually grow crops. And they put the soil to good use, and that's actually a good use of the land. So courts like economic efficiency. The common law courts have this thirst for economic efficiency, and adverse possession is one application of this. There's also a moral aspect to it. Now, imagine, where was I up to? Wesley, yeah. So Wesley, imagine if, you were living in a house for 29 years, right? You've been there for almost 3 decades. And, you bought this house 3 decades ago, and you find out on year number 29 that the person who sold it to you was a crook, right? He gave you a deed, you recorded it at the records office, and he was a crook. He was a sham. Out of nowhere, the true owner shows up, right? He was, overseas, wherever. He comes back, it's like, haha, Wesley's in my house. And you've been there for like 29 years. Why do you think adverse possession here works to say, too bad, I keep it?
Well, I think that within 29 years, you've already set up your life, already set up your family, property. So to go in at that final year and push you out, it seems almost cruel.
Yeah. And that's another reason why you have adverse possession. It's not only for the person like Mr. Robinson, who is like, yeah, I know I don't own it, but I want to own it in the future. In some cases, it also protects good faith people like Wesley, who bought a piece of property, they got a deed, they thought it was legitimate, everything looked good, and then 3 decades later they find, just kidding, there's really an owner somewhere else, and the person who sold it to you is a crook. Right? So any questions on the general idea of adverse possession? Any questions on the general premise of adverse possession? Yes, Yusef?
Yeah, would he be able to give, they said in the video that he didn't have any water running or electricity.
That's the problem. So this is actually a problem with squatters. The utility companies won't run power or cable or electricity or anything if they don't have true ownership. So it often happens, and this is why there's a safety risk for adverse possession. They run it from a neighbor, right? They run basically a hose, right? They run a hose from a neighbor. I've seen cases where they run these long extension cords outside. That's not safe. People have actually seen running gas lines to try and get natural gas. They try and jerry-rig a hookup. So there's a legitimate health and safety risk of squatters fucking with utilities. It's not a joke. Because if you're running like a power cable 30 feet and it starts raining, you can burn down the house, right? Anyway, so this happens. But back in common law, when you had farms, you didn't have hookups, right? You didn't need to rely on the state for any services. So, if Farmer A left and Farmer B started tilling the soil, they're like, okay, whatever, because the soil's still getting tilled. But yeah, good question. There's legitimate health problems when you have this sort of thing. Also sanitation, when people are squatting in homes they don't own, they don't always take the best care of the place because they don't actually own it quite yet. So Mr. Robinson looks like kept pretty clean, had the chair and everything else, but there are cases where squatters aren't so clean. Yes, is that Lauren?
Yes.
Yes, ma'am.
So in that case, I know you can take ownership through adverse possession by just being there seasonally or just showing up. So in that case, because you don't have the utilities needed to be sanitary or be safe, could you just come in for like an hour a day, sit there, and maybe clean up a little bit, and then leave, mow the lawn?
Okay. So you're asking a very good question, right? And this is actually a very good lead-in to the first case, the Valkenburgh versus Lutz case. How much time does a squatter need to actually spend on a piece of property to acquire it by adverse possession? Or to use Lauren's framing of the question a little bit differently, what if instead of living in a home, you just go there for a couple hours, you clean up, do whatever, then you go back to your own house for the day, right? Is that enough? Okay, so let's answer that question by going through the 4 elements of adverse possession. Mark?
Just before, when you were talking about the 29 years on a fake deed, I understand how that works in that context, but when you're talking about a fake deed, are we talking about 5 or 10 years? Because as long as I have a deed, if it's not fake, or if it is fake...
If you have a deed, it's 5 years, and depending how you've registered it, it can be 3 years.
Okay.
I don't want to get too far into the specifics of that, but that's generally how it works.
Okay, thank you.
But I want to answer Lauren's question by going through the 4 elements of adverse possession. I think Chester mentioned them a couple minutes ago, but let's walk through them again. All right, Alexandra, give me the first. And by the way, I type all the lecture notes up here. If you saw my handwriting, you'll realize why I type. Every day at the class blog, you'll have a post that looks something like this, and there'll be a link. It's probably hard to see, but click on that link. That's a Google Doc, and that's the notes. So don't feel compelled to copy and paste everything I write because it's up here. So I'll type it up here. If you have a computer, you can open this in one of your tabs. If you don't have a computer, you can just look up here. But everything is available for everyone. So, Alexandra, what is the very first element to assert a claim for adverse possession?
Entry.
Yes, ma'am. Okay, explain. What is entry?
You have to actually enter the land.
Good.
And usually there's some kind of like exclusiveness So like maybe for the fence, you claim that specific area.
Good. So let me pause you for a minute, Alex. Sorry, my sister's name is Alex, so I'm going to call you Alex, even if you don't want me to. Okay, fine. It's like whenever I meet an Alexandra, my sister's Alex, I just instinctively say Alex, so I'll apologize in advance. So Alex, by the way, I like first names. You can call me Josh. I don't like formalities. That's fine. So Alex, you learned in a class last year. What do you call it when you enter someone else's property without permission? A trespass. So think about that for a second, right? Like connect towards some property for a bit. The very act of adverse possession, the very first thing you do is you commit a trespass. And that's not just a tort, that's also a crime, right? You can go arrest. So, right, so Alex, someone walks on your land and they say, hey, Alex, I'm your new squatter. What do you do?
That's not good.
Yeah, no, not good. What do you do?
Probably tell them to get off my land.
Okay, you tell them, you're very nice. You tell them to get off your land. So Rita, what do you do usually if someone...
I mean, I would also call the cops.
You'd also call the cops. Yes. And you say, this person has entered my land, right? So, but there's a reason why, Samrita. Why is the entry so important to trigger the clock to start counting for adverse possession? Why is that act of entry so significant?
Well, because it starts the statute of limitations.
Yes. It starts the clock, right? You need a specific act, the act of entry, to start tick, 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 right? Let the clock go tick. Because unless you have a specific date of entry, it's unclear when you start the clock. I've had exam questions in the past where it wasn't exactly clear when a person entered a piece of property. Right? They walked near it. Maybe they had some stuff shipped to it. They had their belongings. You know, what? These are sometimes hard questions. When does the clock start to tick? Okay. Is that Bradley?
Yes, sir.
Bradley, but it's not enough merely to enter, right? What's the second condition you need to establish a claim of adverse possession?
So after entering exclusivity, it's open and notorious.
Right, okay. What does open and notorious mean, Bradley?
Basically that you're telling everybody, hey, I'm here.
Right, I used to say notorious B.I.G., now people also know notorious R.B.G., right? Notoriety, right? Notoriety is you're making it publicly known that you are now squatting, right? Is that Emma? Mm-hmm. Thank you, ma'am. Emma, how do you make it open and notorious that you are squatting, that you are trying to assert a claim of adverse possession? What do you have to do?
Using the land, or
okay.
Typically, like it's using it how the regular owner would, and
yes, and I think that's the answer to Lauren's question. You hear that? What you just said? You use the land as the regular owner would. Everyone understand, right? So, I'll give you an easy example, right? Lane? Mm-hmm. Lane, what happens if you're trying to adverse possess a beach home? Yeah, by the lake, right? And it's often used for summer vacations, but in the winter it freezes over and it's basically inhospitable. How much time would you need to spend there in order to assert a claim of adverse possession?
Well, assuming that the true owner only uses it during the summer, then you would only have to use it.
Exactly. Hear what you said? You use it in the same fashion that the original owner would use it. So to Lauren, your question, if the true owner of that house was there 364 days a year, coming in a couple hours a day probably wouldn't cut it.
Well, I would stay there if I don't have no air. So
yeah, and in Texas, the lack of air conditioning. Believe it or not, in Texas, there's a time before air conditioning it existed. I think we'll have a case later this semester. It involves I think from Dallas, where there's a property that doesn't have air conditioning. It's an entire mess.
My air went out yesterday. I'm definitely staying at my house tonight.
Library tonight?
No, my mother-in-law.
Okay, well, fair enough. So the question is, what is open and notorious? You have to put the owner on notice that you're doing this. Right, that's the purpose. Mr. Robinson went on TV. Probably not the smartest idea, but that definitely satisfied the requirement for open and notorious. Right? That definitely satisfied that requirement. There are some cases involving a mine, right? What if you're trying to adverse possess a mine underneath the ground and the person can't see it? Those are tricky cases. I think in that case, the court said that it did not satisfy the requirement, but don't want to go too far off course. Okay, block. Okay, Taylor. Taylor, what is the third element we have for adverse possession?
That you use it continuously.
Continuous. Very good. And this is also somewhat in response to Lauren's question. What does it mean continuous?
Well, it'd be the same if the true owner would continuously use it just for the summer, then you would use it for that summer, but it's throughout the entire statutory period. So you can't just like put a chair there and sit in it sometimes.
Yeah, exactly. You have to use it for the period of time continuously. But that doesn't mean you're chained there 24 hours a day. You can come and go as a true owner would. You notice numbers 2 and 3 are pretty similar. Yeah, someone's going to ask you, Josh, what's the difference between 2 and 3? They're pretty much the same. There's a lot of overlap. Number 2 focuses more on how you put the person on notice. Number 3 is how long did you put the person on notice for, but it's the same basic, the same basic question. Okay? The last one is the hardest one. Was anyone confused about the last one? I'm sorry. Oh, someone, you have a question?
Well, I was just going to say, so like in the situation with the guy, how he had no electricity or water, for it to be continuous, since it doesn't have to be constant, could he use it as the regular owner would by just stopping by every day and like checking on things and then leaving, but he did it every single day?
Maybe. I think a court would probably require you sleeping over and living in the house as a person would live in the house, like spending the night there. That would probably be the requirement.
So if he just went there to sleep every night?
But living in the house, right? It's coming home after work or coming home after school, spending the night, leaving in the morning, and doing that 7 days a week. That would probably be how you define continuity. Thank you. Now, yeah, Jess.
Would that view be objective unless the adverse possession of the moving party is to his advantage for the subjective view? So pretty much what I'm saying, like when the court looks at how the normal owner would have used it, I'm assuming that's an objective view, but what if the adverse possessor says, like, the guy before was only there 1 month out of the year?
Well, that's an evidentiary issue, isn't it? Right? So you would need an affidavit of some sort, right, from the true owner saying, here's how I lived in my house. And then you would have Mr. Robinson challenge that affidavit, saying, no, he actually only came here on weekends, right? But that's an evidentiary issue that goes to the continuity.
So is it objective or is it circumstantial?
How many of you have objective evidence of how often you sleep in your home? Probably not many, right? I think probably an affidavit of your own usage would suffice. Anything else? Let's focus on the fourth issue, the fourth element for a minute. This is the element that often gives students the most difficulty, and the book unfortunately doesn't explain it very well. People are smiling. It's a hard element to define because it seems to run into the other elements. So it's called the claim of right. Okay? It's sometimes called claim of title. You'll see it sometimes called that also. T-I-T-L-E. I once had a person write on my evaluations that I don't spell well. So I try to take good care to spell correctly. A little red line. Because when it's spelled wrong, the red line pops up. Oh, Blackman can't spell, right? It's called claim of right or claim of title. I don't want you to use the second word. The reason why I don't want you to use the claim of title is that you will confuse it with color of title. I promise you, on the exam, someone will write color of title when they mean claim of title. I promise it'll happen. I'm warning you, first day of class, 30 minutes in, one of you will do it. Promise. Don't call it that. Save yourself the heartbreak and just call it the claim of right. Okay? Agree? Now, what is a claim of right? Now, if you just look at the words, it means, well, you have a claim to the land. That's simple, right? Here, the actual wording is somewhat misleading because that's not exactly what it is. Okay? It refers generally to a state of mind in a broad sense, and we'll do some examples later on in class. But it generally refers to the state of mind of the squatter, right? what is his state of mind when he goes into this adverse possession? Okay, that's the general definition. We'll drill down into a few different types after we do the next case, but that's the general gist. Is everyone okay with that? Okay. Everyone all right with this so far? All right. Let's do the next case, or I guess the first case of the semester. I have a fancy map. I drew this myself. It's not very good, but it's better than the one in the book. So you're stuck with it. Mia. All right. Give me the facts, please, in von Valkenburgh versus Lutz. A lovely name for a case.
Okay, so the Lutz family bought a couple of lots in New York.
Okay, what lot numbers did the Lutz families buy?
14 and 15.
Ah, now you see why diagram is useful, right? So the Lutzes bought lots number 14 and 15. Okay, and here's the plot where the lots are. By the way, did anyone know what a paper street is? Did everyone see that in the reading? A paper street? Does anyone know what that is?
Is that, am I being confused with Paper Town? Is it a fake street?
Yeah, I didn't know that. Very good.
From the novel Paper Towns by John Green.
Very good, yeah. Or Fight Club. Oh, yeah, he lived on Paper Street. Yeah. A paper street, this is actually kind of cool. In the olden days before Google, if you made a map, how would you prevent someone from copying your map? You would make a fake street. You would draw a fake street and you call it a paper street. That way, if someone else had that exact same fake street, it's like, aha, they copied my map. So there's a paper street, I think it was called Leroy Place or something, or Leroy Avenue, which is fake. It's not real. Anyway, so the Lutzes bought lots number 14 to 15, and Mia, what happened next?
So over time, they started using some sort of like path or easement into their.
Oh, you used the magic word. Okay, what's an easement? You're exactly right, but let's talk about that for a minute. What's an easement?
Like a kind of, I imagine it as like a cut-through path or something.
Yeah. So you all know what this is, right? Their house was here. And notice this is not a real street. That's why I drew it in over there. It was very difficult for them to get to the main street. They found it was much easier to walk across this other land, which was lots 19 through 22, and go to the main street. All right? So we've discussed adverse possession, right? That is, Mr. Robinson sitting in a home for 3 or 5 or 10 years, whatever it is, and then he gets a claim to own the house. But short of adverse possession of property, there's another concept to consider. It's called, right up here, prescription. Prescription, right? That's not like when you get a letter from your doctor to get like a prescription for a medicine. Prescription, or you'll see it also as prescriptive right, means you've acquired by adverse possession the right to cross over a piece of property. So we discussed here, what if you sit in what if Mr. Robinson sits in the house for a decade? He'll gain title to the land by adverse possession. But, is that Maria? Say, Maria, what if instead of Mr. Robinson sitting in that house for a decade, what if every day for a decade he crossed over the lawn and he walked from one end of the lawn to another? He did the same thing every morning for a decade. Exactly. The elements are identical. The same way that you can obtain land by adverse possession, you can obtain an easement, what Mia said, that is the right to walk across something, by adverse possession. We call that a prescriptive right. That is, if you cross over a land for a decade, there's your entry. You do it openly, you're walking. You do it continuously, every day for a decade, and you do it with the correct claim of right. It's now yours. You have the right to cross that. In other words, if you're crossing that, he can't call the cops and sue for trespass. You now have a right to cross your land. Yeah, Bradley.
So when you have that prescriptive right, how does it? So let's say I'm walking across somebody's land and they call the cops. How do the cops know about that prescriptive right before they arrest me?
Now, have you been doing it for a decade already?
Yes.
So you're walking over the land for a decade, right? And then on year number 11, he finally calls the cops. So here's what you do. He calls the cops and he says, trespass. You go to court. You raise as your defense what? What's your defense?
The prescriptive right.
And what does the court hold?
They're in my favor.
Exactly. That's how this is litigated, right? He calls the cops, says he's trespassing. You say, no, 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 no. I've established by the elements of prescription, the 4 elements I got him, mine. And now the crazy part is, you're now a part owner to his property. So anytime he sells his land to another person, he sells it with your prescriptive right on it. So they have to deal with you. I mean, not that it's bad, but they have to deal with you in any future event. I often give this example in class, but Rockefeller Center, right? Everyone knows like 30 Rock. It's in New York City, right by where the big Christmas tree is. Every year for one day, they shut down the street for one day. Why do they do that?
To set up the ice skating rink?
Well, no, not just at the ice skating rink.
Light up the Christmas.
They block public access to the sidewalk for one day every year. One day. Usually it's in July at some point, not a high traffic day. Why? Raise your hands. Raise your hands. Why do you think this Rockefeller... Yeah, Lauren?
So that you would have to, either you have something there, you have to move it, or you have to move yourself. You can't go on it, so that way you can't have this type of description.
Yes, to deny someone continuity. They shut down the public sidewalk one day a year to deny someone continuous access to Rockefeller Center so someone can't claim prescriptive right. There was actually a guy, he died a couple years ago, but every single morning at 5 a.m. he would go see the Today Show. Right? Know the Today Show? Filmed at 30 Rock? He would go there every single day and watch it. Now imagine that guy walked across 30 Rock every single day for 10 years. He'd be like, hey NBC, General Electric, Universal, hi, I'm your neighbor, right? I'm your co-owner. So you can gain a prescriptive easement by walking across property in all these jurisdictions. Everyone understand that? I'm sorry? I heard a voice. My listening skills are not good, my hearing skills are. As my guidance counselor told me at least. Yeah, Matthew.
The use, what you're using it for, it doesn't matter. Like if you're simply walking, or do they look more?
Well, if you use it for walking, that's what your easement's for. Right? Because imagine, I'll use another example. Let's say you walk across a path every day for a decade, and then you get your prescriptive easement. Then you get your car out. You want to drive along the Rockefeller Center. No go. Right? You use the easement for what you actually have. Other questions? Yes, ma'am.
How does the exclusivity run into that?
So the exclusivity, very good question, doesn't really apply when you're using it just to pass through. Because you can imagine with Rockefeller Center, there are tens of thousands of people every day walking that path. But it's, you do it every morning, maybe at 8 a.m., you cross to go to work, whatever it is. Do you have a question?
Yeah, I was thinking if I lost it at the
A lawsuit?
No, I lost it.
Oh, you lost it. Okay, that's
I lost my
fine.
question.
Okay, if it comes back later, you can raise your hand. Yeah,
I have a question about easements like roads. If you have one continuous piece of land and another person's land is landlocked, they have an easement, and you want to fence them off so your animals or whatever don't cross over the path and get run over, you're going to pay taxes on that. You're going to be paying the property taxes on that easement, but the person who has the easement is never going to give you any money for it.
Well, in some situations when courts find that you have a prescriptive easement, they require you to pay for it. So in some situations, the person doesn't get off scot-free, he pays for it. Right? But let's walk through the case. Is that William? Sure. Okay, so William, how did Mr. Lutz travel across the land? What was he actually doing for all that time?
He was cutting across vacant lot, basically.
Yeah, for how long?
A long time.
Yeah. Yeah, I mean, decades, right? A long time. Did Mr. Lutz acquire prescriptive easement to cross that land?
Yes.
Okay, he did. Now, his lawyer said something very stupid in court during one of the earlier proceedings, right? What dumb thing did his lawyer say?
They acknowledged that somebody else owned it.
Oh. This, my friends, is why property is important, right? The lawyer for Mr. Lutz made a very big mistake that screwed up the entire case that lasted like decades. The lawyer for Mr. Lutz said, okay, he would, see this orange arrow, right? He would cross these lots, numbers 19 through 22, and that established a prescriptive easement, but the lawyer conceded, he admitted in open court that he didn't own this land. All right, Travis, you're Mr. Lutz's lawyer. What do you argue? What's a much smarter argument? We got South Texas lawyers, right? Real lawyers. What do you argue there? Well, not just prescriptive right. What else does he have? Yes. Why does he have adverse possession? You're his lawyer. What's the argument? Ah, the lot is unowned. What? I can't say that. Alexander? Oh, God, two Alexes in a row. Perfect. Alex, walk me through the four elements of adverse possession here, right? Did Mr. Lutz meet the required elements?
Well, he had entry.
Okay, so he entered the land. Good. What else happened?
It was open and notorious.
Okay, how do we know it was open and notorious?
People, the public, saw what he did.
Yeah, it was known as like the Lutz garden, the Lutz home, Charlie's house, right? He built a house there. What sort of stuff did he do on the land?
He planted gardens.
He had a garden. Good. What else did he do?
Built that house. Right?
Built the shed. Right. Very good. So was it continuous? Was it for a long enough period?
Yeah, it was continuous.
Okay. And what was his state of mind there?
That he believed it was his.
He thought it was his. Yeah. I think, and I think everyone agrees with me, he had a pretty good claim for adverse possession, but his lawyer made a bad argument. His lawyer argued only that he acquired the prescriptive easement. Okay, so he got his prescriptive easement, and then what happened next? That's Travis. Oh, two Travises. Okay, Travis, what happens next?
So after he gets the easement.
Yeah. What happens next?
He filed a counterclaim.
Okay.
For adverse possession.
Okay. Well, but what happened first though? Before the adverse possession, right? What was the genesis of the current case? What did von Valkenburgh do?
Trying to evict him.
Yeah. So von Valkenburgh tried to evict Lutz off the land and said you have to remove your house, you have to remove your garden, you have to remove everything else. Okay? So the basis of the case before us here is not about the prescriptive easement. That was resolved in an earlier matter. The case we have here is about the adverse possession for this little red triangle-shaped lot over here. Okay? And that's page. So what does the majority... always read the dissents. Dissents are always very important. What does the majority here do here, Paige? Louder, I can't hear you, please.
The trial court found him Lutz.
Okay.
That he can use his path to travel, and that he, the appellate court reversed that.
Good.
And the land wasn't being improved because of that, and the defendants of Van Valkenburgh say the land legally, but the Lutzes could still access it.
Okay. Very good. So the majority ruled against the Lutzes. Caitlin, which element of our four elements we have here did the majority find was lacking? We have four elements. Which element of these four did the majority find lacking? Justice Dye, or Judge Dye, I should say.
They talk about him not really improving on land.
Yeah.
I'm not sure if that would fall under.
Okay. By the way, in New York, the highest court is the New York Court of Appeals. This is a confusing element. In New York, the Supreme Court is actually the trial court. The reason why is because it has general jurisdiction or supreme jurisdiction. The highest court in New York is called the New York Court of Appeals. Maryland, to my knowledge, is the only other state with that setup. So the New York Court of Appeals, Caitlin said, is right. They said he didn't make enough improvements on the land. Where does that fit in our framework? I think it goes to continuity. They don't quite put it there, but that's where it makes sense. That he didn't continuously use the land in the appropriate manner. Right? He certainly entered, and he did it in an obvious fashion, but he didn't use it in the correct fashion. All right? Now, Jesse, why did the majority think that the land wasn't used in the proper fashion here?
They said it wasn't improved enough. Just having like some shed, a couple plants wasn't enough to show actual improvement that would be open and notorious as the true owner would use it.
That's exactly right. What do you think about that, Jesse?
I mean, just a small shed there and a couple plants, I agree, but if it's known as his garden and it's a big garden, all that crap, then I mean, maybe.
Yeah. Isaac, what do you think?
Well, they built a second house on property, did he not? For the son?
Yeah, they built the house. Yeah, exactly.
One would think that that would be sufficient to...
Why do you think, Isaac, the majority thought that was inadequate?
I don't know. I agree with the center that if you're going to build a house, you're de facto saying that you're not going to build a house on someone else's property. You're going to build a house on that property, which is yours. But I suppose they disagree with that concept.
Yeah. So the majority makes a lot of fuss saying, having some sheds and some chickens and whatever else they had there, that was not adequate. Jesse, what happened?
They really just care about state of mind that he wasn't his, and they, I mean, even today after Connecticut doctors, they still, of course, today they want
right.
to,
So I think Jesse's right. The majority seems to be putting a lot on it wasn't substantial usage, but the state of mind, right? The claim of right was really what was driving the majority's opinion. Is that Michael? Michael, what was Mr. Lutz's state of mind during this entire time that the shed was built there and everything was built there?
I'm just going to build a house here and own this.
Did he think he owned it? No. So he was like, I don't own it and I don't care. Is that was the state of mind?
Fair assessment.
Does the New York Court of Appeals think that's the correct state of mind for adverse possession?
No.
Right. This part was probably wrong, right? They're basically saying you can only squat there if you think you own it. But if you think you own it, then you have a different sort of claim altogether. Mr. Lutz was the quintessential hostile adverse possessor. He's like, I own this. I'm sorry, I don't own it, but I don't care. I'm staying here anyway. Okay, let's walk through the dissent. That's is that Avery? Avery, what was the dissent's argument here?
They said that the fact that Lutz seems he did not own the land is irrelevant.
Yeah. Why is that irrelevant?
Because despite knowing that, he took steps to exert control.
Yeah. I mean, this is a black letter exercise of adverse possession, right? You know you don't own it, you don't really care, and you go on the land and you make improvements, you build stuff, you use it in a good way for the requisite period of time. And traditionally, that's enough, right? Jillian, what does the dissent note about the fact that the lawyer screwed up, right? That in the earlier case, the lawyer said he didn't own it. What does the dissent make about that? What point does the dissent make there?
About the lawyer not knowing.
Yeah. Does it matter that in a previous action the lawyer said he didn't own it? Why? What difference does that make?
Because if you, can you repeat the question, sorry?
Did it make a difference for the dissent that the lawyer had admitted Lutz didn't own the land?
Yes.
What difference did it make?
That, that changed the whole, that fact that he owned the...
Should it have changed that fact? Should it have changed the case?
Oh, no.
Why not?
Because he already didn't own the land.
No, Adam? What? Did the fact that the lawyer said something important make any difference legally? Now, there's not a state of mind. In property, how do you transfer a piece of property? Think all the way back to last semester. There's a statute which I'm sure you hate very much. Oh, it comes back. Dahlia? sorry, Delilah, I'm sorry. What's that statute you guys learned about how to transfer something of value? What? Who remembers? That statute. You know it. The statute of
fraud.
Statute of
frauds being right.
The statute of frauds. Okay, try it again. What is the statute of frauds? Oh, what is the statute of What is the statute of frauds, Delilah? Do you remember? Tyler?
The first limitations on how you can sell and transfer property.
What is the major limitation of the statute of frauds? Must be in writing. And not just in writing, it has to be signed by
both parties.
Ah. Thank you. I know it was a long summer, right? The statute of frauds. The statute of frauds, which you all learned, I think at least 2 classes last year. The statute of frauds, which you all learned at some point last year, says to transfer property, you need to have a written instrument signed by both parties to be charged. If Mr. Lutz acquired this land by adverse possession, Delilah, I'll go back to you. If he acquired it by adverse possession, does his lawyer making some representation in a brief convey it to someone else? No, why not? Can a lawyer sell property on behalf of someone without the owner's signature? Exactly. So the point here is, the mere fact that the lawyer messed up, and lawyers do mess up, and he should get sued for malpractice, the mere fact that lawyers mess up doesn't get rid of the property. And the dissent says you can't orally relinquish. There's this phrase which probably looked odd when you saw it, right? Orally or oral relinquishment. You can't orally give up a piece of property. The only way to convey a property is with the statute of frauds, written instrument. Everyone with me on that one, right? So here the lawyer's terms. By the way, malpractice, you often heard this word. What does that mean? If you're a lawyer, right, and you make some mistake, it's not just oh, whoopsie, I made a mistake, or you do your legal writing memo and you mess up, oh, wow, I got a B in 7A. You could get sued. Your client will not be happy that he made a mistake, and as a result, he lost the case. And he maybe lost his home, and he lost his property. And a mistake isn't just means you write the wrong word in a brief or your blue booking's bad. No. The course will not throw you out for blue booking errors, I promise. But the failure to raise this argument that you acquired the land by adverse possession, that is malpractice. In other words, your client only was seeking this little prescriptive easement, but you could have gotten the entire property yourself. The failure to raise that means you're going to be in trouble, and you're going to malpractice suit, and you'll get a bar complaint, and you may get suspended from the bar for a bit, and you'll get a public sanction against you. Are you taking professional responsibility this semester? It's not just a class to help you learn some stupid rules, right? These are important things that keep your law license active. You all want to be lawyers. You want to have a career. Don't screw up, because in a decision you make in a heartbeat, a quick decision you make in an instant, you can lose your license. You'll never get it back. Maybe you will, maybe you won't. You'll have that little mark on your record. There is that record that does exist, and when law firms want to hire you, they'll know. Oh wow, he screwed up this case. Maybe I'll hire someone else. So legal ethics is not just about memorizing rules and the modern model rules, whatever it is. This is an important class. So anyway, the bottom line of this case, the bottom line of this von Valkenburgh versus Lutz case, is that the majority wasn't convinced that he had used the land in the correct fashion and that he had the wrong state of mind. The dissent, which I think probably gets the better of the argument, I'm more inclined to the dissent, says he had chickens, he had farm, he had crops, and he had the exact right state of mind. He wanted to take the land, even though he knew he didn't own it. There was a fairly lengthy aftermath of the case, litigation back and forth. Eventually, the Lutzes were able to keep the land, ironically, due to a lawyering error from the von Valkenburgh. So bad lawyering all around. Okay. Any other questions on von Valkenburgh? Yes, Anthony.
How important do you think it was for this appeals court that didn't they buy the land from the city?
Yeah.
Do you think it was more the policy part of we don't want people squatting on city property for 10 years and it's being taken away from the state?
I don't know, but I mean, once the von Valkenburgs bought it from the city, it wasn't the city's land anymore.
But
right?
it had been abandoned. I mean, the city hadn't done anything with it for 40 years.
Yeah. There are some jurisdictions where you can't squat against the government. Some places you can, some you can't. I'm not sure how much of a difference that would have made.
If they can't squat against the government, then he wouldn't have had adverse possession at all because the owner was
yeah,
the city.
The
right?
clock started much earlier. Yeah. So, Bradley?
When someone has that prescriptive right, since that's a right, they're able to sell that right to someone else? So if I'm walking across somebody's land, I can sell
We'll do that next class. So the short answer is you can tack. That is, if two people want to squat, person A from the first 5 years and then person B for the next 5 years. If there's a relationship between the two of them, you can actually bridge that gap. But you'll read that in class for Thursday. Anything else about Valkenburgh? Let's go back to the fourth element, claim of right, and let's talk about their state of minds, right? And you've done the idea of a state of mind in crim. You probably talked about it in tort with negligence. We have it in property. Depending on the rule of a jurisdiction, courts will actually inquire as to the squatter's state of mind. What was I up to? I think I lost my track. Is that you? I can't see your tag. What's your name?
Stormy.
Stormy. Okay. What's the objective state of mind?
It's basically irrelevant.
You can't give me more than 2 words, right? What does that mean to have an objective state of mind? Just give me a full sentence. You're right.
That the state of mind is irrelevant.
Yeah, the state of mind is irrelevant. Thank you, okay? With the objective standard, the state of mind is irrelevant, okay? In other words, it doesn't matter if the person knows he owns a land, doesn't know he owns a land, is there to be a jerk and wants to squat. It makes no difference whatsoever. So under the objective state of mind, which I think is a standard in the UK and in a number of jurisdictions, the final element, the fourth element, is basically irrelevant. Oh, right? That probably a few of you are thinking about that. If you take the idea that it's irrelevant what the state of mind is, then everyone meets the fourth factor of adverse possession. You can't not meet it. Everyone who is on the land, by definition, has the correct state of mind. By definition, you have the claim of right. So litigation over the fourth element of adverse possession only matters in the other two sorts of jurisdiction. The good faith and the what's called the aggressive trespasser standard, right? If you're in a jurisdiction with this state of mind, which was what was adopted in Manillo, the fourth element is basically a wash. Doesn't matter. Everyone meets it. Everyone with me? Okay. Is that Antonella? Ma'am, tell me, what is the good faith standard number 2?
It's that you didn't know, you believe that the land belonged to you, but
Yeah.
it ends up not belonging to you.
Yeah, I describe this with this. Well, I thought I owned it, right? Right? I thought it was mine. It was basically an accident. It was inadvertent. Right? It's inadvertent. You thought you owned it, you made a mistake. This is like the example I gave to Wesley some time ago, where you're living in the house for 30 years, you have a deed that looks legitimate, guy selling to look honest, turns out it was a fraud. So this is what's called the good faith. I thought I owned it. You know, wasn't a mistake. Okay. Now we have aggressive trespasser. That's Katie. Katie, give me an example of what it means to be an aggressive trespasser.
Basically, you know it's not yours.
Yeah.
Like the way that, or they're not using it, they want to use it for themselves.
Yeah. The aggressive trespasser is Mr. Robinson, right? From the first video. It's like, I thought I didn't own it, but I intended to make it mine. This is Mr. Robinson. I know I don't own it. I will own it. This was a standard adopted by the Preble doctrine from Maine. It also can be called a bad faith standard, right? So you have symmetry. You have the good faith standard. I thought I owned it. This is the bad faith standard. Well, I know I don't own it, but too damn bad. I'm going to get it. Historically, at common law, the most common, popular one was the third one, the bad faith standard. But the modern trend, we always look at property in trends, like what's the modern trend, is towards abandoning that and moving towards the good faith standard. Okay. All right. So in our remaining time, let's talk about the last case, Manillo v. Gorski. What am I up to? Is that you? Is that Nicole? All right, Nicole. Give me the facts of Manillo. You can tell if these facts like, oh man, right? What are the facts here?
Okay, so basically, the guy, there were adjacent properties, and he built steps from the side of his house, but it was, like I said, a really minor encroachment.
How much are we talking about?
15 inches.
Yeah, about like this, right? I mean, we're not talking about a lot. So what happened?
Yeah, so...
how long were the steps built like that over this borderline of 15 inches?
It was a long time ago.
Yeah, right. So I did this row, right? Did I do this row? Okay, Lauren.
Yeah, we did.
Eventually, someone always throws someone else under. Lauren, in a normal case, what would neighbors do in this situation when you find out that there's like a 15-inch gap?
Well, they were saying that they should have surveyed to make sure that they wasn't encroaching on that property.
Before they built, right?
Right.
Okay, they didn't do that here. But in a normal situation, what would neighbors do with this sort of dispute? One at a time, please, one at a time. Oh, so what do you think was going on between these two neighbors? They did not like each other, right? I think Lauren's on point. In a normal world, if your neighbor says, you're on my property by 15 inches, okay, or pay me for it, right? Not, let's take this to the Supreme Court of the state, which is what happened here. So, Justin, under the old rule New Jersey, which was this aggressive trespasser, this hostile doctrine, right? Did they make a claim for adverse possession? Under the old doctrine, we have to have this malicious intent.
No.
Why not?
Because she didn't know, she believed it belonged to her.
Yeah, it was a good faith standard, right? She said, I thought it was mine. So under the New Jersey doctrine, before this case, you had to show you were an aggressive trespasser. You had to show that you were hostile. Now, I'm going to give you a hint, which we use from all of your classes. If you ever see a case from the New Jersey Supreme Court, they are about to reverse the common law rule. Without fail, I promise you. Without fail. In Property 1, Property 2, common law. If you see a New Jersey Supreme Court decision, they're about to reverse the common law rule. That's what they do. Right? So Elena, what rule do they then adopt in this decision? I'm sorry? I can't get louder. What rule do they adopt? You have it? Did you read the case? That's not good. Anna? What rule do they adopt?
The main.
Well, the main rule they had before, what rule do they adopt in this new decision?
That it doesn't matter.
Yeah, the objective standard, right? Under the objective standard, Hannon, does it matter that they were unaware of this 15-inch encroachment?
No.
Why does it not matter?
Because the state
state of mind is irrelevant?
Exactly. So the court here abandons this aggressive trespasser standard, and they discard the hostility requirement. Okay? Everyone knows that, right? But that's not the end of the case, right? So, is that Lindsay? Lindsay, what's the very first element of adverse possession we talked about at the start of the class? I'm sorry, the second element.
Yeah, so they're saying that the open and notorious element wasn't met here.
Why was the open and notorious element not satisfied here?
They were saying that a minor encroachment on common boundary does not provide the true owner with knowledge of the adverse possession.
So did the clock ever start ticking? Here's the important point. Unless the owner knows that there's this encroachment, the 10-year limitation doesn't start ticking, right? If there's a 15-inch encroachment, unless you perform a survey, you won't know. Now, can someone tell me what a survey is? You may not have heard that phrase. Do you know what a survey is?
It's like when you have someone come and look at your land and define the property lines.
Exactly. How do you know where your boundary is, where their boundary is? Just because you have a fence somewhere doesn't mean that's the correct boundary. So a survey is a fairly rigorous process whereby you find where the boundary lines are. And what the court basically says here is when you have an encroachment so small that requires a survey, there's no presumption that the owner actually knows. And it's unfair to assume the owner knows based on a 15-inch encroachment. So what the court does is they remand it back to the lower court to determine, was there actual knowledge of this 15-inch encroachment? And if so, what sort of consideration is required? I think that was a fairly, putting aside the abandonment of the main doctrine, that was a reasonable way to handle this. Because if the neighbor was never on notice of the encroachment, it's unfair to make him give up his property. After all was said and done, they settled the case for $250 after all this litigating. Most property disputes, almost every case you guys will read, is because neighbors hate each other. Most of these disputes can be resolved by in 5 minutes over a beer, right? Instead, they go litigated all the way up to the Supreme Court of the state, and lawyers are not free. So these people hate each other. The Valkenburghs and the Lutzes, you have here the Manillos and the Gorskis, they do not like each other. Okay? Okay, any questions on Manillo? Oh, yeah.
With regard to the actual knowledge, does that include constructive knowledge? So that's is that a part of it? So if they should have known, they still.
Okay, I'll give you an example. What if there was no actual knowledge, but the neighbor said, "Hey, by the way, I think I'm like about a foot over the boundary line, but I'm not really sure." That may be enough to put him on notice. So better to stay quiet. All right, let me wrap up and summarize a bit. And I always try to finish every class with a summary so you know more or less what we were talking about. The entire doctrine of adverse possession is premised on ensuring that rights to property are clarified in a reasonable time frame. 3 years, 5 years, 10 years, whatever it is. We don't want property sitting around going to poor use. And the elements of adverse possession are designed to make sure that the true owner has every conceivable opportunity to kick out the squatter. The act of entry is the trespass. It's saying, hey, I'm on your land. Okay, I'm going to evict you. If you don't evict him then, okay, I am openly using this land so that people know about it. Okay, I'm still not going to evict you. And I'm going to use it in this fashion for 3 years, 5 years, 10 years, whatever it happens to be. Okay, I'm still not going to evict you. Those steps are designed to give every chance for the owner of record to kick out the squatter. The final element is one that's been more or less wiped off the books in the past number of years, of what state of mind or what claim of right is present. Under the aggressive doctrine, you have to show, I want to take it. But under the modern rule, the state of mind is irrelevant. Any questions? Yes?
Is it really irrelevant, or when it is aggressive, don't they aren't they a lot stricter on the first three requirements?
That may be true, right? So even where they make an objective standard, you can see the New Jersey Supreme Court made the notorious one a little bit tougher to satisfy. So that's a good point. Yeah, Valerie.
So the modern trend is towards objective instead of the.
Yes, ma'am. Anything else? I will see you all on Thursday. Thank you very much.